Hello and welcome, everyone. My name is Nienke Grossman, and I'm a professor of law at the University of Baltimore School of Law and co-chair of the Advancing Gender Justice signature topic at CEJIL, along with Christina Bahari of Foley Hoag and Carrie Bettinger Lopez of the University of Miami. The Advancing Gender Justice signature topic aims to explore areas of agreement and divergence in global efforts to achieve gender justice, to highlight successes and failures, examine limitations, and assess obstacles and consider strategies for achieving gender justice in international law and institutions. With an emphasis on listening and dialogue, the signature topic is utilizing various modalities, including interviews, panels, expert gatherings, focus groups, and webinars like this one, to engage with and collect insights from individuals within and beyond CEJIL. Today, we're happy to be co-hosting an event on taking stock of initiatives for inclusive and meaningful participation of women in international law, along with the Gqual campaign for gender parity, the Working Group on Gender Parity for the International Court of Justice, and the Institute for African Women in Law. The goals for today are to get a better sense of where we are today, what has already been done, what remains outstanding, and challenges to advancing the equal participation of women in all their diversity as a component of achieving gender justice, while keeping in mind that some people might question the extent to which it is an essential component. I'm really looking forward to hearing from our speakers today, all of whom have been involved in efforts to increase the participation of women in all their diversity in various spaces of international law. I will start by introducing each of them briefly, then they will each answer a couple of questions relevant to our topic, and then we hope to have some time for Q&A at the end, which we will we'll be collecting your questions via the Q&A button on the bottom of your screen. So we encourage you to put in some questions as we go along. So let me start now with the introductions. So Dr. Jessica Lynn Corsi is a senior law lecturer at City St. George's University of London, a founding faculty member of City St. George's Interdisciplinary Violence and Society Research Center, and the co-founder and co-chair of the Working Group on Gender Parity for the International Court of Justice, an international working group of practitioners and academics working collectively to ensure gender parity in the international judiciary. Her research and partnerships address how law can prevent and alleviate violence and foster substantive and transformative equality, and spans public international law, criminal law, and interdisciplinary approaches. Jarpa Dawuni is an associate professor of political science at Howard University and the founder and executive director of the nonprofit organization, the Institute for African Women. She is also author and editor of various books and publications involving women judges, both at the national and international levels, and she's co-editor of the forthcoming Oxford Handbook of Women and International Law. Anne-Marie Goetz is a political analyst and policymaker who has worked on women's political participation, democracy promotion, anti-corruption, conflict resolution, and peace building. She is a clinical professor at the Center for Global Affairs, School of Professional Studies, New York University, and has worked on women, peace, and security at the United Nations. She has authored a number of publications on gender and governance, most recently National Women's Machineries, Trojan Horses or Hostages, a chapter in the Handbook of Feminist Governance. Maria Noel Leoni is a Uruguayan human rights lawyer and the Deputy Executive Director of CEJIL. She is also co-founder and director of Gqual, a campaign for gender parity in international decision-making. Previously, she was regional manager for Latin America at the Business and Human Rights Resource Center, legal advisor to the UN Special Rapporteur on Torture, and director of the Anti-Torture Initiative at American University, Washington College of Law. Well, I'm so excited to hear from all of these wonderful experts. We're going to start with the question, in your area of expertise, Where are we today on women's inclusive and equal participation? What has already been achieved? And I'll ask Maria to start us off, and then we'll turn after that to Jarpa, Jessica, and then, Jarpa, Jessica, and then Anne Marie. Thank you. Go ahead, Maria.
Well, thank you, Nienke, and well, it's wonderful to be here. And hi also to, the wonderful colleagues who are joining us online and of course in the panel. So on where we are, I think we are at a critical moment because we've seen real progress towards women's equal and inclusive participation in international decision making, and we need to protect that progress and build on it and learn from it. And at the same time, we're still far from where we need to be, and we continue to face some of the old challenges while at the same time, facing new challenges. So it's quite a critical moment for this issue and this conversation, I think. And but you were asking Yankee about what we have achieved, and I'll try focusing on that glass half full for the first part of the conversation, highlighting some of the areas where we at Gqual have seen progress in the last 10 years since we started the campaign. And I think I highlight four areas. The first one is that I think it is important that the community around this issue has grown and diversified. And when we started Gqual, the conversation was mostly an academic one, and today there's a much broader and interconnected network of actors that brings together activists and diplomats and judges and academics and members of international organizations. And I think this shift has helped make this agenda more action-oriented and more strategic and more visible, and it has helped to connect sectors and agendas from international justice to peace and security to multilateralism and so on. And I think that's very much progress and important. A second area where I think we've seen progress is the legal and normative framework has evolved. We have always framed women's participation in international decision making as a human right, and we've seen traction in this area. And one key milestone to mention is the adoption of General Recommendation 40 by the CEDAW Committee in 2024, because GR 40 came to clarify what the CEDAW Convention means by equal and inclusive participation, defining gender parity as the standard for equality and framing it as a permanent and non-negotiable feature of representation, and it explicitly includes international spaces within the scope of protection of that right. And I think progress in the law helps to clarify obligations and provide a legal basis to hold institutions and states accountable. And then a third area of progress is one that I think is quite visible because the international composition of some bodies and mechanisms do reflect that more women are being appointed, and some bodies have achieved gender parity for the first time. In the bodies that Gqual track, we've seen the gender gap shorten by 65% since we started the campaign. And that includes the Inter-American Court and Commission reaching parity for the first time, the court going from 0 women to parity. In the UN special procedures, women's representation rose from 39% to 66%, and the number of mandates never held by women dropped from 19 to 7. And just recently, the OAS appointed its first woman assistant secretary general in 18 years. And what I think is even more telling is the increasing women running for this role. Across the positions that we track, we've seen 52% rise in women candidates and a 34% increase in candidates from the Global South. So I think that matters because it shows that the issue is not a lack of qualified women, and it puts pressure on the systems to respond. And then a last area where I think we've seen progress, though slower, is on institutional practice, particularly in making selection processes more transparent and introducing measures to ensure that gender balance and parity become a criteria, which is at the core of what we do at Gqual. And there are many examples, but for the sake of time, I'll just mention a few. The Human Rights Council and the OAS have adopted at least 12 resolutions addressing the lack of gender balance in key international bodies and adopting institutional roadmaps and recommendations to states and to the organizations themselves. In the Americas, we have tracked at least 7 states implementing some sort of procedure for nominating candidates to international positions. 2 of them, Argentina and Paraguay, have regulated them and repeating them over time. And in the Inter-American system, some statutes of international bodies have been amended to introduce measures that promote women's equal participation. For example, extending the deadlines of nominations whenever the pool of candidates does not reflect gender balance. So, all of these combined, a stronger network of factors, a more clear legal framework, more women running and being appointed, and institutional changes to support equality make for positive progress and provide us with a path forward and, to learn from it and continue building on that.
Thanks so much, Maria, for getting us started with all that fascinating data and information. Okay, so now we'll turn to Jarpa with the same question. Where are we today on women's equal and inclusive participation? What has already been achieved? Thanks.
Thank you very much, Nienke, and to all my colleagues on this call. I'm very excited to be here. So I'm going to position myself and declare my positionality as speaking specifically from the African continent and the research I have done, which is my strongest suit. Having said that, I'm very happy that Maria has started off giving us some global perspectives, maybe narrowing in onto the Latin American context, but also looking global and giving us the good news. So to answer my question, where are we and what progress has been made? I want to talk about 3 key issues. One, I will call it preliminary. We are still in the very preliminary stages of getting women into these spaces and creating an equal and inclusive participatory atmosphere for women. Why do I call it preliminary? If you look at the history of international law, whichever how far you want to take it, and you look and track at when women came into these spaces, whether in international courts and tribunals or other bodies within the international system, it is very recent. So it's still preliminary, and this is important to highlight because of little progress that has been made. We are already seeing the backlash in different courts where they say, well, women are now taking over. Now we have more women than men. The question is, why didn't we have those agitations when women were not there at all? Women had to come in and make those claims for representation. So let us be very clear, women haven't arrived yet. Point number 2, I would say that we have made progress, but the progress is variegated. It's not equal within all courts, whether at the African level, the sub-regional level, within the global south, if you want to call it, and the global level. If you look at different courts, and I'm sure maybe Jessica will talk about it, so I don't want to go into all the details, you find out that different courts have made different progress at different times. For example, the ICC is a good case where we see that from the very foundation of that court, a deliberate and intentional efforts were made to ensure that they would have more women. Progress has been sustained, but we always have to watch out. For example, within the African context, the ECOWAS Court, the Economic Community of West African States Court, based in Abuja, was one of the leading courts which had 30% women at a certain point, but right now we are at 1 woman. So progress is going back and we need to work on that. So it's variegated. And the third one is inconsistency, which also goes to the variegation. It's been inconsistent. Sometimes it goes up, it goes down. The East African Court of Justice, based in Arusha, is one of the courts within the continent that has consistently, at least it hasn't been inconsistent, it has consistently had the lowest number of women. But if you look at the ICC, African women's representation as a proportion of all judges has consistently been high. Now I'm going to share some data very quickly and you will see what I'm talking about. So this is data which is part of the broader data the Institute for African Women in Law has been collecting for the past 3 years. We're just about to release a one for 2025, which records data from the previous year. The gender scorecard shows that if you look at it here, the African Court on Human and People's Rights has had the highest number of women represented. Of course, it's based on the continent. 100% of the judges are African, so it makes sense. It's one of the global courts that has reached parity at a very quicker pace compared to courts that have existed for long, for example, the ICJ, the International Court of Justice. So the African Court stands as a good example, and we can talk about the reasons why it made a success. And of course, as I mentioned, the East African Court of Justice has had the lowest number, and the ICJ, as a proportion, of course, we know has the lowest number of women generally. So the only woman from the continent of Africa, the Ugandan judge on there, represents 7% of the judges on that court. Now, this will be available on our website. You can digest it, look it up, and get more information. So to end up on this issue, with the 1 minute I have, the three words I started off with is that it's been preliminary, or it still is preliminary. Women haven't arrived yet, so let's hold back our backlash horses. Two, the success is variegated, and so different courts have had some success, others are still struggling. And three, it's inconsistent. So even courts that have had success, there's been some rollbacks, and we need to continue to push for that. And that is what the Institute for African Women in Law did in 2021, when we supported fully the election, the campaign, and eventual election of Professor Phoebe Okowa, the Kenyan jurist, who still remains, unfortunately, the first and only African woman to serve on the International Law Commission. And we hope that progress will be achieved in that area as well. So with that, I hand over back to you, Nienke. Thanks.
Thanks so much, Jarpa, and I fully agree with you on holding back the backlash horses as long as we possibly can. All right, so next we'll turn to Jessica. Go ahead.
Thank you. Thanks so much, everyone. It's great to be here. I'm going to focus on the International Court of Justice in my role as co-chair of the Working Group for Gender Parity at the ICJ. And like Maria, I'm going to start by noting some positive signs and echo Jarpa's caution that we're not there yet. And yet we can note a positive trend, perhaps too slow, but at least it's moving in the right direction. I'll say 5 points. So the first point is, over the past several years, and this is in part due to civil society campaigning, such as from the Institute, such as from Jarpa, such as from academics like Nienke and Anne-Marie, the number of women judges on the International Court of Justice has slightly increased. Presently, 4 out of the 15 permanent ICJ judges are women, or 27% of the court. So if we think in terms of normative international legal obligations, of course, that's not gender parity, that's not 50% of the court. And looking at the historical structural inequality at the court, it's a welcome increase, given that for the first 50 years of the International Court of Justice, 100% of judges were men. So we know that it wasn't until 1995 that the first eminently qualified woman jurist was impaneled at the ICJ. Jarpa notes, we've only been making progress recently. And as Maria notes, we're making progress within the past decade. So that's where we're seeing changes, and we can build on this, especially when we look at, for example, Gqual's historical data about the ICJ, which tells us that in comparison to today's 27% of the permanent judges being women, across the 80 years of the ICJ, historically, only 5% of the permanent judges have been women. So we welcome this progress, and of course, we continue to call for more. Secondly, we are in what might be called the nomination season for candidates for the role of judge at the International Court of Justice. The previous election, where 4 women were achieved in November 2023, will be followed by the next election in November 2026. At present, there are 3 women nominated for the role of judge at the International Court of Justice, and they are all incredibly qualified international jurists. So first we have Ambassador Rina Lee from Singapore. We have Professor Phoebe Akawa from Kenya, current sitting ILC member, and we have Judge Luz del Carmen Ibanez of Peru, a judge from the International Criminal Court and also an ambassador. If all of these women are elected in November 2026, and assuming no current women judges leave the court, we could possibly achieve 7 out of the 15 ICJ judges being women. So we see an opportunity to achieve near gender parity in the upcoming elections, and we'll return to what's necessary to achieve that later in this webinar, I'm sure, when we talk about challenges and what can be done to remove existing barriers. Third, I want to echo how powerful General Recommendation 40 from the CEDAW committee is. So Maria mentioned it and mentioned that it affirms and clarifies existing public international law obligations. It could not be more crystal clear following General Recommendation 40 issued in October of last year that there is a fundamental human right to equal and inclusive participation for women at all levels of the judiciary, including the international judiciary, including the International Court of Justice. So this is a welcome reaffirmation that has been seconded at the highest level, for example, by the United Nations High Commissioner for Human Rights. There is no doubt that there's a fundamental human right to the equal empanelment of women judges at the International Court of Justice. Fourth, I think it's a sign of progress that states continue to engage in meaningful dialogue on this topic. So for example, in October 2025, the same day, fortuitously, that General Recommendation 40 was issued, we organized, we being the working group, a side event at the United Nations International Law Week, co-sponsored by Sweden and Liechtenstein, showing state support for the topic, and co-sponsored by the International Bar Association. And it was a wonderful event which included interventions from state representatives such as the ambassador from Cape Verde, legal ministers from Mexico and Singapore, and the attendance and participation included many other states, including 2 current ICJ judicial candidates. And I think, like Maria said, it's important to continue to welcome this dialogue and this engagement at these highest levels, because the ICJ elections are political. It requires states, either in the form of national groups at the Permanent Court of Arbitration or their equivalents, such as at the national level of government, to choose to nominate qualified international jurists. And then it requires states, when they elect these candidates through the United Nations General Assembly and through the United Nations Security Council in November 2026, to be committed to participating, to fulfilling, rather, their legal obligation to gender parity when they are nominating and when they are voting. So we really welcome this dialogue and this engagement from all partners on the issue. And then finally, fifth, I would count our working group as progress, and building again on Maria's comment on the appetite for engagement and dialogue. So Gqual has been doing wonderful work for 10 years. Jarpa's Institute has been doing wonderful work for a very long time. And building on that, we launched the working group for gender parity at the ICJ in 2023, because the ICJ elections are unique and are political, and because the ICJ is such an important international court and yet significantly lags behind. And I would say we can count progress and taking stock of where we are in the fact that we're comprised of dozens and dozens of very diverse members from practice and from academia, representing all regions of the world, and a really diverse set of positions and values. And I think that's very supportive of a fully inclusive and equal judiciary, including at the ICJ. So that's where we are today in terms of the nominations for ICJ judicial candidates and current sitting judges amongst the permanent judges. There's lots to be done, and I'm looking forward to discussing how we can achieve true gender parity for the court as we move through the webinar.
Thanks so much, Jessica. And now we will turn to Anne Marie.
Hi, everybody. Thank you so much for this discussion. I'm going to be kind of quick here because I think I have more to say about the challenges facing the women, peace, and security field than what has been achieved. But let me just say, women, peace, and security, the imperative of engaging women in conflict resolution and long-term peace building is closely related to gender issues in international law, obviously, because so many international law challenges arise in conflict and related to human rights abuses in conflict. GR 40 actually identified peace and political stability as the first on the list of very serious challenge areas in which what it calls a surge in parity is urgently needed. And that's because peace and security institutions, whether at the multilateral or national level, are historically heavily dominated by men, with cultures that valorize combative masculinity. This is, of course, particularly marked in security establishments and ministries of defense, for example, or in the military. But it's actually also true in the worlds of diplomacy, foreign policy, and, of course, international law. And that is why one of the most important wide-ranging parity initiatives in recent years at the UN, the Secretary General's 2017 Gender Parity Strategy, that's why actually they made a special case out of the peace and security institutions. So the deadline that the SG set himself back in 2017 to achieve gender parity across the UN, he set himself a deadline of 2026 in a couple, well, in next year. But for peace and security, he set a deadline of 2028, past the end of his term, I would also note. So the kinds of problems he's looking at there, let me just give an example. In UN peacekeeping, women are currently only 10% of UN military peacekeepers, 20% of military experts, but in a good development, 31% of individual police officers. That's in UN peacekeeping. In UN civilian staff in peacekeeping and political missions, women are currently only about 26%, which is very, very low. And leadership, women's leadership of political missions and peacekeeping missions is at about 36%. So that's down actually significantly from the achievement of gender parity in peace and political missions, which was achieved in 2020. And in fact, there has been across the board at the UN a slight loss of momentum around the parity effort. Actually, that coincides with the Secretary General's second term. It became less of a marked priority. I can post here in the chat an evaluation of the SG's parity effort if anybody is interested. This all, of course, has an impact on, the real substance of women, peace, and security work. So, for example, it's actually not looking good, I'm afraid. In 2023, women were only 9.6% of negotiators in peace talks. None of the 2023 agreements that were signed in Syria, Yemen, Libya, and Sudan had women signatories. So that's not terrific news. On the other hand, within the UN, parts of the UN are doing better, like the UN mediation teams. Women are 40% of staff. All of this leads up to what difference does this make in peace agreements? And we want to see more peace agreements with gender provisions in them to ensure post-conflict peace building and justice actually is done with a gender perspective. And gender provisions are actually more common now in peace agreements, although that varies year on year. I'm actually going to stop right there because I've got more to say on the challenges side.
Thanks so much, Anne-Marie, and thanks so much to everybody so far for the really insightful and helpful remarks. So now in this second round of questions, we're going to turn to what remains to be done. And I think Anne-Marie started to get us going on this. So the question for this round is, or the questions are, what remains to be done? What are the challenges to achieving the meaningful and inclusive participation of women in all their diversity? And how do we overcome those challenges? And I'm actually going to turn right back to Anne-Marie and ask her to get us started, and then we'll take it from there.
Okay, great. All right, so I've got three big challenges. The first one is the leadership pool from which peace and security leaders can be drawn from is already highly masculinized. And although there are plenty of professional areas from which women peace builders, negotiators, and military leaders can be drawn, there is a tendency, not just in the UN, but individual member states, to choose professionals from very, very narrow fields. In particular, weirdly, for mediation work, people who are chosen as mediators are former ministers of defense, former foreign policy leaders, or former presidents. And we know that numbers of women in those positions continues to be low. Of course, the answer here is to sort of broaden the understanding of the skills that women bring. But the fact is that the pools from which you find those women are very small. And as the Global Gender Gap Report shows, women in cabinets around the world are just 23%, and that's a 0.5 percent increase from last year. At this rate, we're never going to get to parity, let alone women in those positions that we want them in. Second problem, and this is a very sweeping one, is that there's a change in the nature of how conflict resolution is being approached. This is a substantive concern, and it's linked to the autocratization of so many countries and basically the rise of illiberal peace building. So let's not forget, international law, international humanitarian, international human rights law is grounded in this notion of liberalism, liberal international rights. Liberal peace building is all about inclusiveness, participation, consultation, and comprehensive agreements, best example of which is, of course, Colombia 2016. And the conflict landscape is changing. There's an increasing resort to illiberal ways of resolving conflict, which basically means one-sided military victory. So that is actually ruling out possibilities for negotiation, reconstituting the social contract, which is so important for women, and also for building peace missions that contribute to addressing the root causes of conflict. Now, the third trend is, of course, the backlash against gender equality, which Jarpa mentioned. And I have to just say, as an aside, it's so interesting that the reaction to women in positions, in powerful positions, is, "Oh, we're doing just fine. We've got some." Whereas, in fact, it's very few women cause a backlash reaction. Very little attention to gender equality triggers a backlash reaction. There's a quote, I can't remember who said it, but when you're used to dominance, equality feels like oppression. So anyway, so what we're finding is there's a backlash against gender equality, attacks on women, human rights defenders, LGBT groups, and so on. But also there's a backlash against the pursuit of gender equality in peacemaking around the world. Now, this was most explicitly expressed by the current Secretary of State for Defense from the US on April 29th, when he canceled the Defense Department's Women, Peace, and Security program, which actually President Trump had signed into law in 2017. And he called it, I quote, "another woke, divisive social justice initiative that overburdens our commanders and troops, distracting from our core task, war fighting." Interesting. I thought that the defense was there for defense and peace. And he went on to call it a United Nations program pursued by feminists and left-wing activists, which of course discounts the role of women all over the world at the grassroots seeking women, peace, and security. And yes, they are feminists, and that's not so bad. So these attacks on gender equality in the peace and security realm are really, really a matter of urgent, immediate concern. And I will finish on this point, which is illiberal peace building plus gender backlash or anti-gender backlash adds up to a sharp contraction in international peace and security work. So there's been a sharp reduction of UN missions, no new ones for many, many years now, a sharp reduction in the size of mediation teams, the number of peace talks, and so on. And As you all probably know, the United Nations is going through an internal reform process, UN at 80, which is looking at minimum 20% cutting of jobs, positions, and so on, merging agencies, seeking efficiencies. Okay, that's nothing new there. The UN does this constantly, this kind of soul searching. But one of the problems that you can see right away is that managers are looking for low-hanging fruit to chop. And what do you think the low-hanging fruit is? It's the gender unit. It's the gender experts. It's the gender advisors, including women protection advisors on preventing sexual violence. So that is a really big worry. So it's not just gender parity that's going to suffer, and that's already been announced as a fact, but also the gender equality work. I'll stop there.
Thanks, Anne Marie. We're no longer in as good a mood as we were for the first half of the webinar. And you know, it's I guess we always have to be able to hold contradictory realities simultaneously. So thank you for sharing all of that really important information with us about what is happening with the Women, Peace, and Security agenda right now and the ways that it is under attack. So now we'll turn to Jarpa, and the question again is, what remains to be done? What are the challenges? And also, how do we overcome those challenges? Thank you.
Thank you. No, Anne-Marie, that was wonderful. I wish you could keep going on because those are really important issues you raised, the complexities within the current or ongoing global context we find ourselves. And if I may add just a bit to that, you know, the conflict situation, women in peace and security, we also need to think about it broadly as beyond conflicts or battlegrounds. So, you know, once again, this is not my area, but I just keep thinking when we're talking about women in peace and peacemaking and conflict situations, there are all these other multiple levels. It leads to destruction of the environment. It leads to increased migration. And when I talk about migration, I'm talking about internally displaced people, which we often don't look at. Yeah, so most people will look at the continent of Africa as sending people across the Mediterranean to Europe or the Calais border, Dover border between France and, but there are more internally displaced people within the African continent than those who make it outside the borders. And these are also issues that are burdening African countries more than even it burdens the receiving countries abroad. So just putting there as something that I am thinking about, but thank you for setting the context of what needs to be done. So you have given us some of the challenges, and I want to come to from the angle of what can we do? I think but for those of us who work in this area as researchers or scholar activists, we've seen the data, we've seen the work, the research that has been done. So for me, coming from a research perspective, having read enough of Nienke's works, having read Nienke's groundbreaking work, having read and looked at the data from Gqual and all the work that Gqual is doing. I've met Maria in conferences with her yoga mat behind her and going on and on. There's so much that has been done, Jessica's work. And I think this is going to be my simplistic, and hopefully that we stop the talk. Let's just stop the talk. We have enough data. We have enough research to know what the problems are. We have enough experts to know what the problems are. Can we move beyond rhetoric into actual action? Can we look at those recommendations produced by scholars like Nienke? Can we look at those recommendations produced by organizations like Gqual? Can we look at the reports that have been produced by the Institute for African Women in Law? Can we look at the recommendations produced by the working group on the international, the ICJ being led by Jessica and many others? And say, let's sit down and begin to fix these problems. I know it sounds simplistic, but we're tired of talking. Let's move to action. But we cannot do the action alone. So this comes to point number 2, fixing the problems. We need the men. Men, it's time to get involved. It's time to be in these echo chambers because we women are tired of talking to each other. We women are tired of taking care of the wounded in the battlefields, wherever those battlefields are occurring. We women are tired of advocating that women should be in these international courts and tribunals, these spaces that determine global issues. These issues affect more than half of the world's population, that is women, and that consists of women. So we need men, committed men, men who understand that the fundamental issues affecting women affect all of us. The third point, excuse me, it's the issue of context-specific solutions. I know that we have research coming from different regions of the world. We have research that looks at it from a global perspective, but we also need to look at solutions that are context-specific. The issues confronting women running or attempting to get into international courts and tribunals within the African context are different from those that would be facing women in Latin America, in Asia, in Australasia, or anywhere else. So we also need to look at the context-specific issues. We've done some research on that in 2021, leading up to the ILC campaign. We released a report based on a webinar we had, which said, where are the African women in international law? And we looked at these contexts. So context specificity solutions or context-specific solutions will help to deal with context-specific challenges. So I end up on this note. Let's stop talking. Let's fix the issues. But we will not do it on our own. We need men involved. So we need a few good men to be involved in this. And we are working with some of those men already. There are some men who understand the issue of equity, equality, and inclusiveness and what it means, not just for women. Yes, it's okay to be called a feminist. It's the other F word. We will wear it boldly, but we need a few good men who would also take on the F word and help us, the feminist word, and help us move forward. And lastly, let's look at the context-specific issues. So we're not producing blanket solutions, which will not really help address the issue of diversity of women in all their forms. I end here, Nienke.
Thank you very much. Thank you very much, Jarpa, for those very helpful comments. So, okay, so next we have Jess. Again, so the question is, what are the challenges and what can we do to overcome them?
Thank you. Building on Jarpa's very encouraging interventions, I'm going to focus on context-specific challenges for gender parity on the ICJ bench and what we can do both now, right now in 2025, and looking beyond the 2026 election and reiterating what Jarpa has said, which is we have enough research, we have enough data, and we have enough law. What we need is we need political will. We need the relevant actors who have the power to nominate ICJ judicial candidates and those that have the power to elect them to take action and honor their legal obligations for gender parity. So I started by noting that we have made significant progress for women at the ICJ, and I just want to drop in where are we now, what are the challenges using Gqual's historic data, which they'll be releasing in a report, so it'll be available to everyone. But for the purposes of this discussion, just looking at the context of the ICJ, even with the 3 women I mentioned, the eminent jurists who have been nominated for the 2026 elections, if all historic trends over the past 80 years continue, we will not reach gender parity for ICJ judges at the ICJ until 2046. And of course, that's because we've seen in previous elections that when the UN General Assembly and the UN Security Council go to vote for those ICJ candidates that have been nominated, they often do not vote for the eminently qualified women jurists who are on the ballot. So in terms of context-specific solutions for what can happen right now, any state or PCA, Permanent Court of Arbitration National Group, or its equivalent that is still considering nominating a candidate for judge at the International Court of Justice should, all things considered, choose a meritorious woman. In a world of 8.2 billion people, there are more than 15 qualified jurists to sit on the International Court of Justice that are women. All of the current ICJ judicial candidates are incredibly qualified for the job and extremely experienced in international law. All else being considered, the historical underrepresentation of women on the court, which amounts to a serious international human rights violation, must be rectified by a focus on nominating and electing women. So I mentioned in my opening intervention that with the 3 jurists that are currently nominated, 3 women jurists nominated for the ICJ, if the member states decide to vote, and those that make this choice, which will be different for different countries. Sometimes it will be a UN election officer, sometimes it will be the national legal minister, sometimes it will be a committee of people making the choice. They should make the choice to elect enough women in the November 2026 elections to create gender parity on the International Court of Justice for the first time. And this is massively overdue. The International Court of Justice cannot continue to be the world court, the most important standard-setting court for public international law, and be in violation of a fundamental principle of international law at the same time. So that's one thing that can happen now. And it was mentioned by Anne-Marie that the UN has a very clear gender parity policy. I've previously advocated that this be explicitly applied by the relevant UN offices, such as the Secretary General's office, to the nominations and elections for ICJ judicial candidates. There's nothing in the gender parity policy or in the ICJ statute stopping that robust, even if it's facing current challenges, gender parity policy at the UN from being applied to those judges. We've all talked about General Recommendation 40. It sets out very clear roadmaps for what states can do at the national level, like enshrining feminist foreign policy, like enshrining equal representation in international nominations into legislation, into the Constitution. One thing that states can do moving forward at the national level is that they can make their, and Permanent Court of Arbitration national groups can make their nomination selection processes transparent, and they can enshrine gender parity as a requirement for the nominees that they consider. Because again, in a planet of 8.2 billion people, it is very easy for those that nominate ICJ judicial candidates to find the right women for the job. And finally, we're going to need practical support for women candidates. So echoing Jarpa's mention that, for example, African women candidates are not in the same position as say those from Western Europe. It is very expensive and time-consuming to campaign to be elected as a judge at the International Court of Justice. It requires travel. It requires being in the capitals of the world. It requires lobbying in the members area at the UN in New York. So there needs to be practical support. There's a reason why we don't see enough African women judges, why we don't see enough African women representatives on, say, the CEDAW committee. And there's just not enough funding and practical support. And so that's something that, say, the United Nations could set up a trust fund for women judicial candidates as a remedy to the historic violation of our human right to equal representation. There's much more we can do. We have it all written down already. And I love this conversation of talking about how we can solve the problem. What we need is we need partners. We need state partners. We need UN partners. So I hope that we can continue to build those partnerships and turn that into action.
Thanks so much, Jessica. All right, now we turn to Maria. Same question. What can we do? How do we overcome the challenges? Thanks.
Thank you, and thanks for all. Was very inspired to listen to all the perspectives and the challenges, which I think very much resonate with what I can add. But so first, I would like to perhaps go a little bit back to, I was presented sort of the glass half full in the first question, and I think it's very much as Jarpa was saying, very important that at the same time there's a glass half empty. That it's important because like part of this progress that we've seen, I was mentioning that we have seen the gender gap shorten by 65%, but that is marked by at least 3 overlapping trends in the bodies that we monitor that I think help to highlight some of the obstacles that remain and where we can continue, at least, from our mandate in the campaign to focus our attention in what needs to happen. First is that, women's participation has increased at a faster rate in bodies and mechanisms where states' nomination and voting is not a requirement. So, the UN special procedures are a key example of this. It's even when the appointment processes is still very much a political one, the possibility of candidates to directly apply for those positions and the absence of vote trading have made these spaces more open to transparency and to gender considerations. And in contrast, women's participation has been slower in its increase in the bodies where access is marked by states' nominations and vote trading, like the ICJ, but also many other bodies. And I think this shows how critical working on institutional procedures and foreign policies and the political will that Ches was referring to is very much part of overcoming obstacles. I think another trend that we see is that women's participation is higher and has increased a little bit faster in international bodies and mechanisms with human rights mandates, say the Inter-American Court, than in those with mandates more tied to international public law, like, I don't know, the ICJ or the ILC or the International Tribunal of the Law of the Sea. And I believe there's something also there to learn, because I think it has to do with the fact that the lack of women in these bodies that have mandates that are linked to the right to equality and sometimes to promoting women's rights, it generates a more visible and significant risk for the legitimacy on the space. And at the same time, this argument that I think we were all putting forward, that this is resonates more when talking about bodies that have a human right mandate than in those that do not have. And I think there's something that we need to work around that. And then a third trend that is consistent with what Jessica was mentioning is that women's equal participation is much more difficult to achieve, at least in the years that we have been working on this, in judicial spaces than in non-judicial bodies and mechanisms. And I think that has to do with the fact that the selection processes there is where states have most control. And these are at the same time the more influential and prestigious and well-paid positions. So I think, in general, the trend that we see is that the more political and the more state control and the more prestigious and well-paid that the international positions are, the harder it is for women to access on equal footing. And so for us, I think, that helps identify some of the key obstacles that remain and some of the, at least, strategies that we need to still be pursuing to overcome them. And so I'll focus just on the ones that we are working on, because they're not necessarily the only ones, as it was clear from previous presentations. I think, it's clear that there is still a lot of work to do in the lack of transparency in selection processes, both nationally and internationally, and to really frame the issue that the lack of transparency works against women, but it also works against merit-based processes and appointments. And this is one of the, big challenges that we're facing today, but that is a key issue of addressing that as well. And then I think it's also the fact that these processes are oftentimes implemented by a heavily male-dominated network of actors in the foreign ministry and the diplomatic corps. And I think Anne-Marie mentioned about this. So I also think that, addressing the pipelines and the decision-making structures that also, reflect and oftentimes reproduce the underrepresentation is also very critical to continue to be working on this. And then I also think that even with more transparency, the fact that gender parity or gender balance is not a criteria for appointment, it's part of what makes it an afterthought and not a requirement in selecting qualified candidates. And it connects with the fact that some of the gains and the progress that we have seen remain fragile due to the lack of institutional measures in a way to ensure sustainability and prevent the backsliding that we are seeing. So, continue working on building those criteria via GR40, via women's right to equality, and via like good practices and recommendations, I think is important. And then a third thing that I think is critical is really addressing the gender bias and the stereotypes and the intersectional discrimination that underlies all of these obstacles and that continue to shape how we define leadership, merit, and who gets a seat at the table in a way.
Thank you, Maria. I mean, we've come up with a long list of obstacles and some, also a long list of potential. I don't know if solutions or ways. Some of them are solutions. Some of them are ways to mitigate backlash, honestly, and some are ways to actually move, the ball forward and in the direction of parity. So we have, we're almost out of time. We have one question in the Q&A box, which I'll direct Maria to answer. It's involving Gqual. If there are any other attendees who have questions, I just want to encourage you to type them into the chat. So Maria, do you see the question? Or I can read it to you.
I hear the Q&A, right? The Q&A
Yes.
box. Let me see. Oh, yes. Okay.
So does Gqual promote inclusive international legal spaces by pushing for vetting requirements, making sure candidates do not have former allegations of sexual harassment? Interesting question to ask at the current moment, and honestly at any moment, because we always see these. We've definitely seen over time these issues of sexual harassment and misbehavior coming up with people in these positions. Go ahead, Maria.
Yeah, I think it's a critical question and an excellent one. So thank you for whoever who posted this. So we have not conducted vetting processes ourselves, and it's not part necessarily of where we have the capacity to do. But it's definitely part of the guidelines and the standards and the recommendations that we continue to put forward and that we have helped or at least propose within international organizations. So, for example, at the OAS, we have partnered with different states in the region throughout the years to come up with resolutions by the General Assembly addressing the selection of candidates to the Inter-American Commission on the Court, and that has led to a sort of an interview process that it's public, where states get the opportunity to interview candidates in the Permanent Council, and it does not necessarily have a component on sexual allegations, and it should, but it has created a space of sort of vetting process. Parallel to this, as a member of the Center for Justice and International Law, along with other organizations, and taking on the example of what has happened at the ICC as a vetting process, we have promoting an independent panel of experts that assesses all candidates to Inter-American Commission and Court. It receives information from the civil society, and it encourages information, on all candidates, on any kind of information that would affect their qualifications for the role. And of course, these kind of allegations would be very much relevant to that conversation. It interviews all candidates, and then it puts a report, it publishes a report where it assesses each candidate vis-a-vis the requirements. And the requirements include, the moral authority. And so definitely this is something very much relevant to assess. At the UN level, we have partnered with different organizations. This was a first thing that happened last year around the election of members to some of the treaty bodies. We did it with the CEJIL committee and with the Committee on the Rights of Persons with Disability, and if I'm not mistaken, also with the Committee Against Torture. Where we invited all candidates to respond to a questionnaire. We published their CVs, and we did like sort of a public interview with some of the candidates that agreed to participate. So it's initiatives to help with the vetting processes, to make sure that there's more transparency, that civil society actors have an opportunity to hear from the views of candidates. So yeah, but there's still much more to be done on that side.
Thanks so much, Maria. I'll add, just from my own experience, I served on the independent panel of experts in the Inter-American system. And there's a questionnaire that's circulated in 2017. And there's this questionnaire that's circulated to the candidates for the commission and the court. At least in 2017, there was a question about whether there was anything in the background of the candidate that could be embarrassing for the institution, or some language like that, which was a space for that to come out. And I believe that the Advisory Committee on Nominations of the ICC for the judges of the ICC also has similar language in its selection, either the criteria by which it selects the candidates, or it actually asks the candidates in their questionnaire about that issue. So given the time, I mean, we could talk for many more hours about these issues, and everyone on this call, every panelist here has spent many hours and honestly years working on these issues. So I'd like to begin just by thanking Anne-Marie, Jarpa, Jess, and Maria for their reflections today, and also for their work over many years, their blood, sweat, and tears devoted to the issue of increasing the inclusive and equal participation of women in the spaces of international law. I also want to thank the ACIL staff for helping us to put this together, and for supporting the signature topic on advancing gender justice. And of course, I want to thank the attendees who came and spent the time here today, when there's so many issues happening right now that we all want to be learning about. So it means a lot for you to be here. And the video of this event will be made available on the ACIL signature topic website, as well as in other spaces. So we look forward to continuing the conversation on advancing gender justice at additional events coming up. And we thank you for your engagement, and encourage you to keep working on these issues in the ways that you can. Thank you so much, and have a wonderful day.